Dr. Mani sir will be discussing about the recent updates on withdrawal of life support, which is actually a judgment passed by a Supreme Court in 2023. So, Mani sir, over to you. Kindly.
So you see, I want this to be a conversation, a heart to heart. It's not just about the law. So I'll share a short set of slides with you, and so that it's a sort of a preamble for a conversation, and I hope all of us get a chance to speak. All right. Okay. You see, the whole context of today's talk, whole context is about death. What has happened is, with the advances in intensive care, particularly organ support, advances in medicine as a whole, it has distorted our relationship, our understanding with death. See, so we have to renew our relationship, renew our understanding. So, you know, Thich Nhat Hanh, the Zen master, put things in perspective in this calligraphy. A cloud never dies. See, we always think that, you know, we have to be forever, we need immortality, and we don't want to think about human life as fragile, as transient. And this sort of myth has been reinforced by the great promises of modern medicine. You know, we have become a death-defying or death-denying society, and that reflects in our medical practice. We seem to be colluding with this view that we can keep going, and there is sort of, we don't have to talk about death. So this sort of situation has arisen, and until in the 90s or 80s, when we realized there are limitations of modern science, the limitations of technology, and therefore we need to look at it afresh and then relate it with our previous understanding, a more wholesome understanding of life and death. So, you know, last year there was a very significant report on the value of death by the Lancet. There's a Lancet commission which launched this publication January last year, and I was invited for a 5-minute comment on it. And so in real time, they tweeted what I said. You know, we need to recognize death in the ICU. We need to recognize death in the medical ecosystem, which we are not doing very well, because it's become a taboo subject in the society and even within the profession. So we need to recognize it, talk about it, and mention it, because it has great impact. Now, see, the commission brought out the various intersections of dying and grieving, the experience of dying and grieving in the society and in the entire sort of areas of activity of human life, whether it is art, philosophy, metaphysics, or more mundane, political, economic, healthcare, the environmental aspects, also human relationships. Everything gets to interplay when we talk about death. So in the ICU setting or in the hospital setting, death, dying, and grieving needs to be managed appropriately. Not the same way as we manage disease conditions with a curative intent. And then it has to be ethically grounded. Whatever we do, there's so much of technological explosion. Every day we are getting a new technological innovation, to be used. So if we use them appropriately, not abuse them. We need to ground them in ethics. That's very important. And then our decision making in the ICU, not only the identification of the problem, but the management of the problem needs communication, palliative care skills, a legally informed practice, community participation, and national policy. So all these come to interplay in our decision making. So to define in a nutshell, what is withholding and withdrawing? Withholding means we don't start an organ support situation. We don't start an intervention, a technological introduction of organ support, or be that as it may, any sort of monitoring system. Withdrawing is interrupting this ongoing intervention. It may not be just ventilation, it can be so many other things. It may just be antibiotics, for instance, or withdrawal of the routine tests, everyday tests of radiology, withdrawal of vasopressor support, of course. Now, so many other questions have come, so many other forms of withdrawal are being brought to play and questioned. What are they? ECMO, for instance. So what is the state of the human being who is on an extracorporeal support? It is an artificial circulatory system. So are we ethically right in stopping this flow? What happens to, for example, the new devices of intracardiac defibrillators, okay, ICD. Now it's an implanted device. Now what happens? Can we deactivate it when we are facing a terminal situation? So these questions are constant every time we introduce a new technical intervention. So the ethical questions have been addressed since the 1980s, or maybe late 70s, by Beauchamp and Childress. They published the seminal book, Principles of Biomedical Ethics. So our principles of ethics, the four principles, autonomy, beneficence, non-maleficence, and social justice, flow from their concepts. So they are called principlistic ethics, the simplest basis of how we make an ethical decision in the ICU, or in fact in the whole medical ecosystem. But they have to be informed through other principles as well, through other modes, other ways of understanding what we are doing is right or wrong. Deontological ethics means for the thing itself, rule-based. Okay, whatever be the outcome, the right thing to do, right? The Kantian principle of categorical imperative. That is, it's an imperative you have to do something right. Okay? So it's a rule-based system, or it could be a consequentialist or outcome-based, utilitarian. Now, if it has a useful outcome, and then you weigh and consider what is more useful, what is less useful. So this is another sort of thinking which goes into it. Or it could be what is called virtue ethics, character-based. The practitioner must manifest certain character. The practitioner must want his patient and those he's associated with to thrive, which means in every situation in the welfare interest of the patient and the family. So all this comes into play when we take a decision. So from all these points of view, you don't want a state of dying like this one. Complete loss of dignity and absolute loneliness, cut off from the society and family. This is not the way in the entire history of human life people have died. They've died in company of their loved ones, not in the company of these artificial beeps and tubes. Not being unnecessarily prolonged in dying is a criterion for good death, among several others. Criteria of good death have been a matter of debate, and there is a meta-analysis of meta-analyses, and they have reduced that to about 11 principles. But out of this, not being unnecessarily prolonged has become to be very, very important in today's world. If we do so, then we harm by prolonging death. There's a loss of dignity, and it's against the bioethical principles I have outlined previously. To the family, it causes untold distress, economic, emotional, and then causes immense dissatisfaction and loss of trust. And it also leaves behind post-traumatic stress disorder, or even worse, complicated grief that lasts a lifetime. The caregiver is not spared. To the caregiver, it causes moral distress. It loses interest, loses meaning in life, and they become insensitive as caregivers when we are not able to practice ethically or do what we want inwardly for our patients and those we are connected with. So-called compassion fatigue takes place. The intention to leave work, leave even the profession takes place. In our midst, it has caused a lot of violence at work. To the health system, of course, there's a lot of resource misutilization. Therefore, we accentuate the iniquities, the injustice in the society through a less thoughtful practice of medicine. It doesn't have to be like this. It doesn't have to be a state, as I showed you in the previous photo. It can be like this. This is a recent one of a patient of mine. You can see he's facing terminal illness due to terminal cancer and heart disease, terminal heart disease. But he's smiling. He's got his thumbs up side. He's in the company of his family, especially his grandchildren. This can be done. This is not in the realms of imagination or utopia. This can be actually done in our midst by conversation, by speaking the truth, by proper disclosure at the right time, and a good exchange of what our goals should be between the physician team and the family and the patient. The Lancet Commission of the value. Now, they call it the value of death, not anything to be shunned or anything to be covered up or treated as taboo, but it is many times to be valued and often celebrated. As you can see, this is a very elderly, 102 years old, holy man who had advanced ILD. And when he was very terminally ill, I went to see him at his ashram, and on the insistence of his followers, who were considerable, and many of those followers were eminent doctors, he took him to the ICU. We had many conversations as to how far we can go or should not go. But the emotions being very intense and the expectations of modern medicine being overly high, the family, that is his followers, opted to put him on a ventilator. I pleaded on the other side, on the side of dignity, on the side of peaceful end for this personage. So we arrived at a compromise after a good conversation. That is, we'll have a time-limited trial, okay, so that we can be more sure whether we are really there at the end of the tether or not. So time limit was set at 48 hours. If nothing was going, then we would withdraw the ventilator. Prior to that, taking him to the ashram, which is what happened. He wasn't doing well, so we followed our our decision of the day before and took him to the ashram with the anticipatory sedation and analgesia. We extubated him and gave him a peaceful, pain-free end. And then he could be positioned in the lotus pose as per the Shastras. So the fitting end could be possible in these circumstances. And the followers, the family was very grateful, and it felt good to us as well that we had done right by our patient. You see, across the world, there is consensus standards of care now. There's been so much talked about EOLC since the 70s, I think, and there's a profusion of literature since the 90s. And now, in the high-income countries and some of the middle-income countries, issues are reasonably settled, although there are many gray areas still. And as new technologies evolve, there are new gray areas to be tackled. However, we have worldwide position statements and guidelines on EOLC, Wellpicus being one such. And there are Indian position statements starting from 2005, the ISCCM ethical position statement, and then iterations. We had iteration along with IAPC, Indian Association of Palliative Care, and then there was Indian Association of Pediatrics also publishing their guidelines. Then there were other recent Indian publications in the last 5 or 6 years, the FICCI Illicit guidelines. Illicit is an advocacy group, End of Life in India, End of Life Care in India Task Force, of which myself, Dr. Srinagesh Simha, and Dr. Rup Gursahani are task force members, and we represent 3 professional bodies: Indian Society of Critical Care Medicine, Indian Association of Palliative Care, and Indian Academy of Neurology. Now, the legal expert Dhwani Mehta is also part of this initiative of Illicit. The Blue Paper was a wonderful document, an updated document on how to make end-of-life decisions and execute them. This is from the Manipal group of hospitals initiated by Dr. Naveen Salens, an eminent palliative care specialist. We have, together with ICMR, prepared a document as guidelines for DNAR, do not attempt resuscitation guidelines. AIMS came out with a wonderful institutional policy document in 2020. It's got published as a journal article as well. End-of-life care in India, a model legal framework, was published by the Vidhi Center for Legal Policy together with Illicit. Now, this is a draft for a legislation on end-of-life care, and this is also available in the public domain. Please have a look at it. Why do we need to do it? Why do we need so much advocacy? It's because the quality of dying index that was published, the most recent on the subject was 2021 by the Lean Foundation in Singapore. You can see the Indian ranking is 59 out of 81 countries, the United Kingdom being number 1. So there's a lot of work to do. Our rating is not flattering, and we need to work on this. There are many barriers and difficulties, and we have always known that from the first publication in 2006 by Barnett and Arora in the IJCCM, wherein 152 specialists, chest and intensive care specialists were interviewed, and they placed the barrier number 1 as a legal vacuum, and then the administrative lack of support. These were the top 2 among so many others, but they were overwhelmingly the top two. They've remained so all through these years since 2006. There was an ACME publication in 2015, that is Asian Cooperation for Medical Ethics, published from Singapore, and in which several of our Indian colleagues also participated. That also placed in the entire Southeast Asia the problems of legal ambiguities and administrative concerns as big barriers and difficulties. We, of course, therefore, this reflects in hospital policies. They are generally lacking, they are not existent for ULC. There are social norms and taboos, and of course, the cost. Cost is a huge problem, because every day's out-of-pocket expense in a hospital, it has an escalating pressure on the family. Most recently, my dear friend and colleague Shiv Kumar Iyer, in a personal communication, he sent me this information. It is his MSc thesis for palliative care medicine from Cardiff. So he did in-depth interviews of 26 intensivists in 2022, and a robust quantitative methodology was employed. Again, these were the concerns that came up. It is a legal vacuum, it is a lack of hospital support in the form of policies and SOPs, and social norms, taboos, the fear among the professionals, what has beset us in the last 2 decades. That is why every bit of legal effort or initiative in India, we have been eagerly looking at whether it's going to improve matters by the bedside for the doctor and for the patient and the family. So the first one was in fact a draft bill published by Indian Law Commission in 2006, the 196th report, which clearly decriminalized withdrawal and withholding, and they separated it from euthanasia, active euthanasia. They said they delinked it from suicide and abetting suicide. However, they did not encourage advance will. They suspected that advance will could be misutilized in India. And number two, they prescribed a procedure that was complicated, that was through the High Court. Similarly, when the Aruna Schonbock case came up in 2011, you know, Aruna Schonbock, who after a very brutal rape had been rendered vegetative for 35 years at that time, and then of course when she died it was 40 years. And then Pinky Virani on her behalf moved a petition for the so-called euthanasia, but then there was a great debate whether passive euthanasia, that is deciding for the life of the patient which was involuntary, that is the patient is not capable neurologically. That question came about, so the right to life and other issues were discussed. But there was hope for decriminalization of mechanical ventilative support and other supports, medical supports, when the court said, yes, in principle, under certain set of conditions, these are allowed. And this was not allowed for Pinky Virani in a petition, because the next of kin, that is the nurses who were looking after her for decades, did not want to remove supports, which for her would have meant removal of artificial feeding. Once again, extrapolating these principles to the general public, they prescribed impractical procedure for future cases based on parents' battery principle. Then cut to 2018. After this, I don't know, Schonbach, things didn't get better for us in terms of ease of EOL's decision making vis-a-vis the laws in India. A writ petition was filed in 2005 by the NGO Common Cause. Now, it was to validate and provide for the execution of advance will for the Indian citizen. Now, we pleaded ISCCM, and I represented the ISCCM. We pleaded in this writ petition in 2010. It came for hearing in 2018, and the judgment was in favor of end-of-life decisions in the form of withdrawal and withholding. It validated legally the right to execute an advance will. So far, so good. So, in principle, an Indian citizen can refuse any sort of medical intervention, and on his or her behalf, by the surrogate, next of kin, or a legally appointed proxy, or on the basis of the advance will. And this was because of the right to autonomy and right to privacy that was enshrined in the Constitution and as interpreted in the previous year's judgment on privacy. However, what happened was, what we gained in the constitutional endorsement of withdrawal, withholding, and execution of advance will, we lost in the procedure. The Supreme Court prescribed a complicated three-tier procedure, which was as good as not having any legal framework, because you had to have a primary board in the hospital, then a secondary boards set up by the district collector, and then a third one to be endorsed by the judicial magistrate of the first class appointed by the district judge. So all these were clearly unworkable, and nobody utilized these provisions all these years. So the Indian Society of Critical Care Medicine, with the help of the Vidhi Center for Legal Policy, appealed for simplification of these guidelines, and this was supported by the illicit. So this came up for hearing first in November 2022 and then finally in January 2023. So there was a negotiated settlement between the government, the Ministry of Health, and the appellants, and very happily, it was a very happy moment. We thought, there was a ray of hope for improving end-of-life care in India, a ray of hope for persons who are dying to have a better quality of dying and better quality of families grieving. So SC simplified the order on passive euthanasia. The simplification is not as per our suggestions, but we came halfway between the very complicated procedure of the 2018 judgment and the projection we had made. We got somewhere in between and had a two-tier procedure. I'll come to that. But very crucial to the success of all this is conversation, right? It's not just about the law. Are we talking to our patients? Are we having a heart-to-heart? Are we talking about goals of care? Or are we only talking just their physiological numbers or lab reports? Are we talking about what they want, their preferences? Are we talking to the family? When the patient is not able to talk directly, are we eliciting are we making a mental picture of what the person could be, not just the disease entity? And are we eliciting what the patient might want or prefer? These are the most important intervention towards end-of-life decision making. Do we make time for this? Or we have time only to mechanically introduce lines and airways and all kinds of technology? This is a question we must ask. It is our own transformation that is required. So I'll come to the miscellaneous application and what were the simplifications done. So in the earlier 2018 decision, the advance will document had to be signed, executed in the presence of 2 attesting witnesses, preferably independent, and countersigned by the JFMC. But the simplification ordered by the Supreme Court is that it need not, it should have 2 attesting witnesses, preferably independent, and attested before a notary or a gazetted officer. This is far more reachable for any simple citizen. The JFMC need not preserve 1 copy. The JFMC need not forward the copy to the Registry of Jurisdictional District Court for being preserved. But of course, the immediate family members should be, members of the executor should be informed. But the present judgment says the copy of the advance directive should be directed to the person or persons named as witnesses and as a proxy, appointed proxy, and as well as to the family physician. So the SC simplification also goes on to say that the executor may choose to incorporate the advance directive as a part of the digital health record. This is an option they've given. And the authorities such as local government, municipal corporation, or the panchayat may appoint a competent authority official who shall be the custodian of the said document. Now, this is something yet to be put in place. So, the current scheme of having a valid end-of-life withdrawal withholding decision is like this. It is applicable to people who have lost decision making and are terminally ill. Now, whether or not they have a valid advance will or not, this is the procedure to be followed. When the treating team is satisfied that the patient has lost capacity and the patient is terminally ill, now you may have an exercise to determine whether the patient is terminally ill or not, or treatment options have been exhausted or not. That is how to prognosticate. Now, that is a purely medical exercise. Of course, that needs great skill and judgment. But once that is done properly, then within the caregiving team, the treating team, that is called the primary medical board, which consists of primary treating physician and 2 other subject experts of more than 5 years experience. Now, the 2018 judgment said at least 20 years experience, and they specified certain specialties which included even psychiatry, and that too is unworkable. Now, this has been modified, 5 years experience. And subject expert, they've left it at that without specificities. They provide an opinion, so the initial opinion by the primary board, and then this is referred to the secondary board. Now, this is where we arrived at a happy medium between the concerns of the government and the appellant and the demands of the appellants. So You have another board, secondary board constituted within the institution with 3 physicians again, with 5 years experience and subject experts. One of them has to be an appointee through the Chief Medical Officer, CMO. So if you have one of them as CMO, the other 2 can be anybody within the hospital. And then within 48 hours, a decision within 48 hours. It's not at the end of 48 hours. It can be within a few minutes even. So within 48 hours, they're going to give a final opinion. And if the 2 boards agree, then you can go ahead with the decision, withdrawal or withholding, simultaneously intimating, in the words of the Supreme Court, intimate, which means informing the judicial magistrate. If the 2 boards do not concur and there is controversy, then if agreed, the family can always, or the treating team of the hospital can seek High Court intervention. Now, law is one piece in this huge puzzle. What we need is a change, a revolutionary change, which will improve matters for all the stakeholders here, the patient, the family, the physicians. The theory of change is a new concept, and now, after much refinement, it's supposed to be 7 steps in it. The first one being envisioning, that is what you want to do and why is it worth achieving. Okay. And then a hard look at the mirror where we are. We are at rank 59. Why so? What are the gaps? Brainstorming is extremely important, and then we identify the steps, and we can take baby steps, each one taken well, generating evidence amidst us, not just conceptual understanding, but actually having hard facts to work with, putting evidence together, and then different elements coming together. Death literacy amongst the professionals, death conversations in the society, all the aspects of death and dying, including healthcare economics and the politics and the environmental concerns and the social justice, all of them coming together. We get a comprehensive understanding of what we need to do and to stand as champions wherever we are, and then make a difference around us. So I would like to end with these take-home messages. Now, we are talking about a larger issue. We are not just talking about some rules and some Supreme Court observations. We are talking about a culture change that is so much needed across the world, but very much so in our midst. Change from technocentric to a human-centric care. And shift of care from physiology to the whole person. Integrate the palliative care principles. Right, this is what we're talking, palliative care principle, a holistic, more holistic approach throughout the disease trajectory, culminating in the care of the dying and the grieving. Use innovations towards patient and family-centered care. So many interventions of a soft nature in communication, in sharing information has taken place, and we need to integrate all that. Advocacy to improve care at the healthcare, legislative, and policy levels. Thank you for your patient hearing. And I would like to now take your questions.
Hello. Hello, good evening. Good evening, sir.
Yeah, Dr. Vijay, please go ahead.
Hello. If a person has made an advance will, and the person goes into coma, and then the relatives have a different thought, then how do we go about it?
You see, an advance will is for this situation only, that you documented your values and wishes and preferences,
Yes.
and they become operational when you lose capacity. But you see, autonomy is one part of the decision-making jigsaw. It is, we also have beneficence and non-maleficence. So doctor has to participate in this decision. He or she integrates the autonomy very much and gives it primacy. But however, the situation that is to hand may not have been envisaged by the patient. There may be certain reversible or easily manageable elements in the current situation, and therefore the appointed proxy or the next of kin must engage in a conversation with the treating physician, and then a rational decision. So this is not a mere, you see, blindly following whatever the patient has said, but actively considering it as a choice and then integrating that into the decision.
Okay.
Okay,
Dr.
somebody has said,
Yes,
can I take this question?
yes,
Suggest
sir.
a few simple practical outcomes to study quality of death. Right.
I don't think that is the remit of this Zoom call or this thing, right? Perhaps you can have a separate discussion with Dr. Mani. Okay. I think the purpose of this is that the Supreme Court judgment that happened, and if you guys go on and try and find out the archives, you will see that my dear friend Dr. R.K. Mani stood for hours together, almost like a peon in a government office, okay, and ensured that the constitutional bench understood what we were talking about, okay. So my request to everybody is, don't talk about other things like research and other things. You can have a separate Zoom call for that, or email or WhatsApp Dr. Mani, and we will discuss about it. All that I wanted to say was this, okay, if I can put it in a very simple term. Earlier, if you wanted to withdraw life support treatment, you had to go to the High Court, which was stupid. And therefore, lots of corporate hospitals or anybody made sure that either you agreed with what they said or they asked the family members to take the person discharged against medical advice. Mercifully, that has changed. But the twist in the tail is this, that there are two committees, each one given a maximum of 48 hours as far as withdrawing life support treatment is concerned. The second committee has to have a nominee of the chief medical officer. And what the Supreme Court has done is, it has not prescribed the procedure. And as far as this is concerned, each state can do independently. So what we have done on behalf of the End of Life Care for India Task Force, as I said, of which Dr. Mani is the chairman, we have created a draft of rules of how the CMOs or the equivalent can appoint that person for the part of the second committee, and that is work in progress. So what I would like to to tell all the take-home message is that there is no reason for discharge against medical advice, and that the Supreme Court has accepted the fact that if it is infructuous to continue, it is very, very much legal to withdraw. Now, as far as the advance directive is concerned, all right, if I say I don't want this, blah, 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 okay, and the family members can discuss whatever it is going to be, my wish is final. That I think is very important. Raj, would you like to comment on that?
Yes, you put it very succinctly, Nagesh. So that is the crux of this talk. But now you feel free. Rajesh, we have time, isn't it, for more questions?
Yes, sir. Yes, sir. We still have like 10 to 15 minutes time.
9 minutes.
Dr. Vinod Gosai, I see your hand is raised. Could you have any questions? Yeah, please, sir. Okay. Dr. Nikhil?
Hi, sir. Permission to speak?
Yeah, please go ahead, sir.
Yeah. So my query was this: like, whenever this, say, the first judgment which came out in 2018 said we needed to go to a judicial first-class magistrate, etc. However, in the last 5 years, we have done whatever non-escalation or withdrawal of care for quite a number of patients, and we have not gone through with this process. But now, what does this, new verdict entail for us? Does it change the way we practice, and in what way?
You see, I have also been practicing withdrawal withholding for a very long time now, maybe 25 years. But what has happened is, for a large-scale application of ethical practices, most of us were very apprehensive, right? Even today, there are so many decisions taken not to institute any particular intervention. Those decisions are quite easy, and you may not go through a big process because that's based on refusal of treatment. But if you have a more complicated, ethically challenging situation, then you even for your own protection and for more clarity, you go through a procedure as prescribed by the Supreme Court. This is for more conviction and for a greater utilization. What has happened in most hospitals? Most hospitals, they have apprehensions, as I mentioned to you, and otherwise their administration is not convinced. So these decisions are not taken, and what happens is patients are sent lama. You must be all familiar with lama. Why does it happen? Because we don't have an understanding, a legal understanding by our Supreme Court, and secondly, we don't have proper ethical training. Now, I hope that all these exercise will sensitize us to the ethical needs, okay? Ethical training. And wherever you have complicated decisions, you may go as per the letter of the law. Yeah.
Raj, if I might add, I can see a few questions about how do you form a secondary committee, do we need to contact, so on and so forth. When Dr. Mani and our legal team were standing in the Supreme Court, and Dr. Mani may have got a backache because he's really bowing down, in front of the constitutional bench. The government was very keen that there should be some control from government. Okay, so the secondary committee must have a representative nominated by the chief medical officer or equivalent, right? Now, you can work with your respective state governments, but I also suggest that hospitals, particularly corporate hospitals, can write to your state government health department and say that this is a Supreme Court judgment. We would like to know how to go about it. Put pressure. Okay. Now, as far as the primary and the secondary committee is concerned, the primary committee is entirely left to the hospital, right? the treating physician, and two others. The secondary committee cannot have anybody from the primary committee. Of the three, two of them can be from your hospital. And if the CMO or equivalent has not formed that committee, you can always appeal to your health, to your whichever department is concerned, that as per the Supreme Court judgment, you guys need to appoint. It is going to take a little while for all these things to be sorted out, but I think it's an excellent victory that has happened, that we have got a clear-cut way forward of how to withdraw or even for that matter withhold life support treatment.
You see, once I agree with Nagesh that, we have to work around this. We have to work with what we have. Now, we can have a permanent committee endorsed or appointed by the CMO within the hospital. And I'm working on this and it will happen. We've approached the CMO, the district, and also the health ministry of the state. I work in Ghaziabad, so I've approached UP, and Dr. Nagesh Simha has approached Bhubaneswar, the Orissa government. So, there's a bit of homework is required. Now, when we had a problem with deceased organ donation, brain death, prior to THOA also people were doing disease organ donation, but they were not clear and they were not doing in large numbers. But after 1994, disease organ donations increased from 1998 onwards. And now it is really accelerated in the last few years. So that's what is going to happen. Once, the public understanding improves, like previously public didn't understand what brain death was. Even the professionals, even till date, many of us are confused. But then a lot of us have understood, and a lot of us have created systems by which organ donation has really taken off. I envisage something very similar. That's why, you can have a committee appointed by the CMO, just as we have a brain death committee. You have 5 or 6 physicians recognized by the CMO within the hospital, and at any point you can call upon them and have a declaration of brain death. Similarly, we can have a secondary board within the hospital, and one person can be taken from the list of appointees from the CMO, and the other 2 can be variable, and you can put together 2 committees. It is very much reasonably possible. See, a primary board is already naturally there. When we are looking after a patient in the ICU, anyway, 3 physicians are involved, 3 different departments are involved by and large. And so the court is only endorsed the current standards of medical practice, it is not a unilateral decision, it is a collective decision, and multiple heads must think through this thing. And we must have a conversation with the family. So all these are in tune with the generally accepted standards in the world. We must make it happen for us.
So Raj, if you look at the conversation, the people are posting. For example, my friend Amol Patel said, can we use the brain death theme for the same? No, you can't. Dr. Mani and company tried desperately. In fact, I think Raj, you would have got a backache after that. You were bowing so much in front of the Justice Joseph. But the government did not agree, right? And my dear friend Ripan Salota said, so we need to follow this procedure, and the primary and secondary board, even for de-escalation or do not. See, the point is this. There is a saying in Hindi called "Aa bail mujhe maar." So don't get into trouble unnecessarily, right? Any amount of clinical decision that you take, but in the ICU, particularly if you have intubated a patient and you want to withdraw, then of course you need to follow all these regulations. Right?
Yes.
And more importantly, you need to convince your hospital, whatever you might call it, and the non-medical legal advisors to your hospital. They are the ones who can become a royal pain. Okay. Now if there is an advance will, then it is clear if no such will and subsidiary spouse was ever been during the treatment or decision making comes, and when patient is unconscious, gives an apprehension of ELH, how to go about it. So Raj, I think you should look at the messages, and I think you're the best person to answer those things.
You see, Nagesh, what I want to say is, see, majority of these decisions are very simple, right? You know, to not having to do CPR, to not giving an antibiotic, to not doing a test, okay, not doing an expensive MRI. Now, for all this, you can take a decision by talking to the family and having everybody's understanding on board. A more complicated one would be removing a ventilator.
Document it.
Yeah. See, documentation is the vital one. Without documentation, your intentions are not honest as interpreted by law. So what I would say is our traditional values in medical practice of documenting everything should be followed. And this is even more so in ethical decision making. Your intents and purposes should be very clearly seen in the case notes. So you have conversations which should be documented. You have a mutually understood position which should be documented. Then rest is easy. Lot of the withdrawal decision, for example, withdrawing the ventilator particularly, right? If you withdraw dialysis, you see, intermittent dialysis, you don't institute, it's not a very complicated decision. But withdrawal ventilator, I think you need to go through these two boards, need to have proper documentation. What I'm saying is I'm still taking these decisions on an everyday basis without any fear. I have no complications. If you go through the basic principles of building trust with the family and engaging in conversations repeatedly, not just one-off and khana purti karna nahi. You have to have a heart-to-heart, right? And then give respect. Whole thing is about respect. Respect the family value. You know, that is the mnemonic value. Value the family, value the patient's preference. When there is a advance will there, it is not a menu card you're given to the patient and you just fulfill it. You respect the value held therein and then think about it. Okay. Supposing somebody has said, I don't want the ventilator, but you got something eminently reversible, like hypokalemia producing, respiratory failure, and which you medically think can be very easily reversed. And therefore, you have to integrate that. But if it is not due to something so reversible as that, then you accept in toto what the patient has said and don't put on ventilator. So now, little bit of common sense has to be used. Whole of medical decision making is judgment based. It's not just a rule based, a formula based at all. It cannot be.
Absolutely.
Yeah.
You have said that ICMR does recognize DNR, but NABH that gives the accreditation. Don't bother Biju about NABH and tell the NABH guys that you need to change your rules.
Yes. So you see, that's why I don't ever overemphasize the legal side. Okay, I always hasten to add that this is only one part of this whole jigsaw puzzle. Maybe just one segment, out of 5 or 6 other segments. The most important is a proper grasp of what ethics are. And our practice should be grounded in ethics, whether or not somebody terminally ill. Okay. Number 2, the intervention of communication. It's not the intervention of putting a vascular catheter or airway catheter. This is another powerful intervention. And that has to go side by side with the so-called technical mechanical intervention. And if you fail that, then you fail the patient and the family and yourself. And of course, the honest disclosure of what is happening and the skill of prognostication, skill of assessing all the elements and all the data of the patient and then putting it all together, crystallizing that in a prognostic statement. Okay. So, and then none of this is formulaic, obviously. As you go along the disease trajectory, your prognosis varies also. So all this variability, uncertainties in intensive care should also be brought into play in your conversation.
Thank you, sir. Thank you, Mani sir. Thank you, Nagesh sir. So anybody has any more questions? We are 5 minutes late from the scheduled timing.
I've answered many queries on the chat box.
Yeah, and Rajesh, if I can suggest,
Yes,
that
sir.
if our friends have any queries, let them email it to you, all right? And you can forward that to Dr. Mani, yeah? And we'll be very happy to interact with them. The bottom line is that finally there is a judgment of the Supreme Court that helps us to withdraw/withhold life support treatment. And I'm happy that it has happened because I was always afraid that my dear friend Dr. Mani might go into jail. That let them so be, okay? That will not happen, right?
Yes.
And if there are any doubts about ethics, etc., and we are trying to work with the state governments to make sure that the chief medical officer understands what he wants to do. Okay, so it's a long process, and we hope we'll be able to complete that in the next maybe 5-6 months. Raj, do you think?
Yes, I'm sure this is going to evolve
Yes.
quicker than we think. Yeah.
Okay. So thank you, everyone. Thanks for joining. Thank you, Mani sir.
Thank you. Thank you.
Thank you all. Thank you for the patient hearing.
Thank you, sir. Thanks, everyone. Thanks, everyone, for joining.